Um, okay, so Ms. Dugas is on probation for the offense of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that? Are there any additions or corrections?
None from the defense, Your Honor. No,
All right, and this was unagreed, correct? Ms. Holmes, you may proceed.
Thank you, Your Honor. I've spoken with Ms. Dugas. Obviously, the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses. Not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Okay, go ahead.
There you go, Ms. West. Complete this probation. I know it's going to be extended if you do gratitude. My name is John. I'm great. I'm being like that on family. We'll never be found the world.
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just rob someone else, you failed to ID, failed to report to probation, you committed the new offense of possession of a controlled substance, you resisted arrest, it's ridiculous to me that you're saying you want a second chance because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Ms. Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that you're stop crying because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity. Right? Ms. Malfino? Sorry.
I don't think I need to add anything to the court. I think that you follow the agreement that age at the very least is appropriate for her based on the number of violations. I spoke with Mr. Chen yesterday. He does not want to continue to work with her. This is actually her third MTRP. It's about her fifth chance in front of you, not just her second chance in that quarter. So
Ms. Dugas, I'm going to find that you entered your pleas of true to counts 1 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of robbery. Going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Ms. Holmes. I hope you take some advantage of this and actually do what you're saying you're going to do when you get out and change your life. There's programs in prison, take advantage of them, but you're not going to continue to get opportunities like this. If you continue to violate the law after this, you're going to be considered a habitual offender. And if you do anything again, your minimum punishment is going to be 25 years. 25 years minimum for what you've been doing. So you need to change your life or you're never going to see your kids, right? Go back with the bailiff. Good morning. Are you Wesley Antoine? And Mr. Antoine is here for sentencing on probation a deferred probation for aggravated assault, family violence, and that was a 10-year deferred probation that he was given back November 14th of 2023. Entered pleas of true, it looks like, to counts 1 through 11 in the motion to revoke unadjudicated probation. I've received an updated pre-sentence report. This was an open plea to the court. Is that correct?
Yes, Your Honor. The court had previously, when we were here before, it advised the court, that he received 4 months on that new case in Louisiana, but it does involve the same victim, Miss Red, as his case here.
Mhm.
We had discussed 6. The court did not feel comfortable with that, so we've just decided to go off to you.
Okay. All right. So that's what, and I wanted to remind myself, I had a notation on this about that new offense. So the new offense was in Louisiana, and it was domestic abuse, battery, also by strangulation, correct? Against the same victim. All right. Mr. Lewis, you may proceed.
Judge, in this situation, of all my conversations with Mr. Antoine here, a lot of his issues come back to his mental health problems. And at the time, I believe he was not really open about getting the help that he needed with these issues. And once he got on probation, of course, those issues really became a very unstable situation. He admitted that he was homeless for a period of time there, which why he went back to Louisiana. All of his family is there. We had some sort of support system. And but Judge, he understands that he did mess up. He understands that, he hasn't done what he needed to on probation. He's taken it out for it. And he's just, at this point, he's asking for any consideration possible for so he can get you out.
Thank you, Mr. Lewis. So on that original pre-sentence report, and the orders that went along with that, I mean, this is a first-degree felony. So on that deferred probation, it specifically ordered all the things that Mr. Lewis is asking for now. You've already had access to all of those things. To be placed on the specialized mental health caseload, to get an evaluation and get any type of help and treatment that is available. You were ordered to do those things. And in fact, what you pled to on this motion, true, is that you didn't get the evaluation completed. And so you never were able to get services. And that was your choice. Everything was given to you. You had all the opportunities in the world to get whatever help you needed so that you could be successful. But the fact that you're on probation, I mean, the allegations in this underlying case is that you had a cane and that you just beat the crap out of Miss Red with that cane while she's on the ground. And then you get out and you get around her again and you strangle her. I mean, it's just beyond me. That's what you would do. I mean, it sounds like if you go to Louisiana, if you have support, that's great. But to go back and do that to her without permission, you weren't working, you didn't have your mental health, you didn't do your community service, you didn't do the batterers intervention prevention program, which probably would have taught you how to not beat on and attack and put your hands on people that you supposedly care about. Got a new offense over there for that. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 11 freely and voluntarily. I'm going to find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault on a family victim. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, that the laws give you the right to receive. I believe the initial was Yes. I am going to make the finding that there was a deadly weapon in that initial case. I'm going to hand you the trial court certification. You need to sign this with Mr. Lewis. It shows that this was not a plea agreement. You have some rights to appeal. You can talk to him about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Lewis. Good luck to you, sir. Sign that, and then you can go back with the bailiff.
This courtroom hearing involves 2 defendants whose probation violations led to serious prison sentences, with the judge taking a strict stance due to repeated offenses and missed opportunities. In the first case, Miss Dugas was originally on probation for second-degree robbery, but she violated nearly every condition of that probation. She admitted, pleaded true to multiple violations, including committing another robbery, failing to report, drug possession, and resisting arrest. Her attorney asked the court to give her another chance, explaining that she lacked support and was going through a difficult time. However, the judge strongly rejected this request, pointing out that probation itself was already her second chance, and she repeated the same behavior, even committing another robbery. The judge emphasized that she had multiple prior opportunities and failed each time. As a result, the court sentenced her to 8 years in prison, noting that even this was lenient compared to what she could have received. The judge warned her that if she continues this pattern after release, she could face habitual offender penalties with a minimum of 25 years. In the second case, Mr. Antoine was on deferred probation for aggravated assault, family violence, a very serious charge. He also violated probation conditions by failing to complete required programs, including mental health treatment and a batterer intervention program, being homeless, and committing a new violent offense in Louisiana, domestic abuse by strangulation against the same victim. His attorney argued that mental health struggles contributed to his actions and asked for leniency. However, the judge pointed out that he had already been given access to treatment and resources, but chose not to follow through. The original offense itself was extremely violent, involving beating the victim with a cane and strangling her, and the new offense showed a continued pattern of abuse. Because of this, the judge revoked